everyone. So we are going to do the second lesson of industrial law today, and that is types of employment. Now, employers give different classifications or labels to their employees. So, for a workman or an employee, it is important that he knows what type of a label he is given, so he can have a better understanding of his rights and entitlements. And as students of law, it is important that you know this too. So we will be discussing 8 types of employment, and the first one we are going to discuss is monthly contract of employment. Now, there's not much about monthly contract of employment to discuss, other than it is type of a permanent employment. Like it is permanent, and this type of contracts are renewed automatically at the end of every month, unless it is terminated by either party with the requisite notice given. And then we have fixed term contracts. Now, as the name suggests, these contracts are contracted for a fixed period. So both the employer and the employee know after entering into the contract when the contract is going to be terminated. And this termination happens as a result of a contractual provision both the parties have agreed to. So the employee has no right to claim re-employment or as renewal of the contract or continued employment, because the termination did not happen as a result of the employer's decision. Also, as I said, there's no guarantee of renewal. It is completely up to the employer uh, to renew the contract or not. But these type of issues can be taken up to the labor will be considered by arbitrators and industrial courts on just and equitable principles. Now, an instance where, if we are going to look for an example where fixed term contracts would be used, now let's say there's an IT company and they have developed a new idea to for a dating app. So what they would do is they will hire someone who is experienced in developing this type of apps, and they will hire him on a fixed term contract in order to develop the app. Then we have temporary contracts of employment. Now, temporary workers are hired to satisfy an employer's temporary needs that are part and parcel of the company. Now, as an example, let's say the receptionist of a particular hotel is on maternity leave. Now, would the administration of this hotel let their guests feel unwelcomed because there's no receptionist to welcome them? Or let the inquiries directed at the reception go unanswered because there's no receptionist to answer them? No, what they would do is they will hire someone to fill in for her until she comes back from her maternity leave. So they will hire this second person on a temporary contract of employment. So from that example, you can see that a temporary contract of employment would be restricted by either time or the job. Now, it is also important that the person who is going to be hired on a temporary contract of employment is made clear that his employment would be one of temporary nature. I suggest that you read the Podu Seva Sangame case for have a better understanding of that. And the next type of employment is casual employment. Now, casual employment is a type of employment that has given rise to so many industrial disputes because one, there's no test to identify a casual worker, and two, employers tend to give this designation to employees that do not fit the description of a casual employee. So now a casual employee is hired by chance, and there will be no contract to employ, and they are usually paid daily wages. Now, an example of a casual worker would be the person your father will call when he thinks the garden needs a bit of a sprucing up. Like there's no prediction of when he's going to call him again. Like it's purely by chance. Yeah, get the idea, right? So yeah. Now, like what I said before, as in like that they are employed to fulfill a task that is not part and parcel of the business, that they are usually paid daily wages, and that they are hired by chance or no contract to employ. These are indicators you can use to identify a casual worker. Now, how does a casual worker can be differentiated from a temporary workman? How you do that is, a temporary employee is hired to fulfill an employer's need that is part and parcel of the business. That is the difference, because casual workers are not hired to fulfill a task that is part and parcel of the business. So on that note, let's move on to probationary employment. Now, what is a probationary period? Now, a probationary period is essentially a trial period where the employer would assess the probationer's aptitude, skills, knowledge, and like basically whether or not he is suitable for the job he's hired for. And at the end of the probationary period, if the employer thinks he's indeed suitable for the position, he would confirm his employment. But if not, he can either terminate the services of the probationer, or he can renew the probationary period if he thinks he should be given another chance, or like he needs more time to prove himself. So now there are some questions you need to know the answer to when you're studying probationary period. Now the first question is, what is the difference between a permanent employee and a probationer? Now the key difference is, when let's say a probationer and a permanent employee has been their services has been terminated, and both of them decide to challenge the termination in a labor tribunal. Now when that happens, when the permanent employee challenged the termination, the burden is on the employer to prove that the termination was justified. But when the probationer challenges the termination, the burden is on the probationer, not on the employer, but on the probationer to prove that the termination was mala fide. He should at least build a prima facie case. And the next question is whether a probationer is entitled to automatic confirmation. Now, let's say a probationer is continuing in his employment even after the probationary period. Now, the probationary period has expired, and yet he is continuing in his employment, but the employer has not, like, he's yet to confirm the position of the probationer. Now is the probationer continuing in his employment in a permanent capacity or as a probationer? Now there's conflicting views on this matter. In the HETIA now, but the generally accepted view is that in such cases the probationer would be continuing in his employment as a probationer, unless the employment contract states otherwise. Now let's say in the contract of employment there's a clause say the probationary period cannot last more than 6 months. Now if the particular probationer who is continuing in his work has passed the 6-month mark, then that means he cannot be regarded as a probationer. That would be contrary to the employment contract to do so. But otherwise he will be regarded as a probationer. But in the Jackson Rupasinghe case, the court had a different view. So you can read up on that case too. Like you need to read up on that case. Then the next question is, can the services of a probationer be terminated during the probationary period? Now, like we are talking about terminating the services of the probationer because the employer thinks he is unsuitable for the job. Now, if the probationer commits an act of misconduct, of course he can be terminated during the probationary period. But like it's not because of that the employer wants to terminate this probationer's services. He wants to terminate the services of the probationer because he thinks he is unsuitable for the job. Now, in a decided case in India, it was held that it is unfair to terminate the services of a probationer during the probationary period, and that the employer should wait until the expiration of the probationary period to exercise his right to terminate. But in Sri Lanka, the view on that particular issue is different. And in cases like Richard Peris and Company Limited versus Jayatunga and Musaji Limited versus Razaya, in those cases it was held that the employer can indeed terminate the services of a probationer if he thinks he is unsuitable for the job, and of course there should be no mala fide involved. And now the next question is, should the employer give warnings or feedback on the performance of the probationer during the probationary period? Now, it is not required by the law to do it, but it is it is pragmatic to do so, because now let's say a probationer has been terminated and he decides to challenge it in a labor tribunal. And who would look better? An employer who has given multiple feedback on the performance of the probationer during the probationary period, or the employer who has given no feedback on the performance of the probationer? Of course, the employer who has given multiple feedback on the performance of the probationer would look better, because those feedbacks would help him to show that the termination was bona fide, that he had no ill intention in terminating the services of the probation, other than that he thought it is that the probationer is unsuitable for the job. Because when it comes to deciding whether a probationer is suitable for the job or not, the employer is the sole judge of that. It is unfair for us or like the labor tribunal or the courts to go and say, no, this person is suitable for your job, you must employ him. No, that is unfair. When deciding whether a probationer is suitable for the job or not, the sole judge would be the employer and no one else. So that's about it for probationary employment. And then we have seasonal employment. Now, seasonal employees would be those who are those small roadside shops that pop up when there's the Vesak season coming up or the Christmas season. Now, people who work in those shops are seasonal employees, because those shops open only during those months like May, December, November. Now the question is, are these should the employer employ these should the employer employ the same workmen for the subsequent seasons also? Now let's say I have been employed by a Vesak Kudu Kadayak in this year's I'm going to be employed by a Vesak Kudu Kadayak in the next not in April but in May. Can I claim re-employment in next year's May? In May 2021, can I claim re-employment by the same employer? Yes, can I do that? Now, the answer to that depends on two things. Like, he can do that only in two instances. One, if in my employment contract, if that employment contract confers upon me or the workman the right to claim re-employment in the next season, then yes, of course, he can claim re-employment. Or if he can prove that the practice of that business, of that particular business, is to employ the same workman in the subsequent seasons also, then in that instance also he can a particular workman can claim re-employment. mm, and then apprentices and trainees. Now, an apprentice is someone who is learning the trade, from his master and is serving him. So the difference between a probationer and an apprentice is that a probationer is tested to see whether or not he is suitable for the job, but an apprentice is tested whether, like, on the skill that he's showing to learn the trade, not actually the knowledge he has on it. How, like, he will be tested how well of a learner he is, how well of a student he is, essentially. So in English law, it is considered the purpose of apprenticeship is considered as to for the apprentice to find better employment and wages. So if the employer backs out of a apprenticeship contract or breaches it, the apprentice can sue him for loss of earning and training for the remaining period of the apprenticeship. Yes, so that's what you need to know on apprentices and trainees. So yeah, looks like we have discussed all the types of employment I planned out to do. And yes, it was not 8 types of employment, it is 7. I'm sorry, that was my mistake. Yes, so that's the end of the second lesson. Now since we have done 2 lessons in industrial law, it means now you can answer the second question of the industrial paper, because usually the second question in the industrial paper comes from either the first lesson or the second lesson. And I think both of these areas are very, like, quite easy for you to understand and quite easy to remember. There's no big sections involved, it's just some theory parts and case law for you to remember. So I hope you study both areas well, and you will score the full 16 marks that is up for grabs in the exam.